Ladies and gentlemen, I'm very happy to be able to welcome you to our first colloquium in this winter term 2023-2024. And I'm really happy that we're, as you can realize from the language I'm speaking, it's getting international today. So I'm really happy to welcome learned friends from the civil procedure from European countries. First foremost, Anne and Thomas Garber, Mr. Neumeier, and of course, Bart Krans from the Netherlands. I'm really happy that we could manage to arrange such a hybrid conference today. And I'm really looking forward to the presentations we'll have in the next 1.5 hours in the discussions. So today we will talk about the challenges we have concerning the digitalization of procedural law from a comparative law perspective. And we decided to take a European view on the matter, not a European Union view, but a European view. And there might be an additional event in the future which will be dealing with external third country perspective. And today we are happy to welcome the lineup I will present to you. We have the first presentation, which is presented by Anne Nyland. She's a professor of civil procedure law at the University of Bergen. She's chair of the Nordic Association of Procedural Law, so she knows what she's talking about. And she has recently edited the book on civil courts coping with COVID. It has been a while since the book has been edited, but if you are interested in how different jurisdictions touch on COVID-19 situation, then you will have the possibility to access the book online, open access. So this is a very nice service we can have there. So Anne Nyland will present some general thoughts and prepare the floor for our country views on specific measures that are undertaken in the Netherlands and in Austria, considering digitalization of civil procedure. Anne Nyland will talk about how to approach digitalization of civil procedure, and we're really interested in learning a bit more from your perspective. The second presentation will be held by our friends from Austria, which is Thomas Garber, who is a professor for civil procedure at Karl Franzens University in Graz, and a specialist in the field as well. And he will join up with Professor Neumeier, who used to be the vice president of the Austrian Supreme Court and also part-time being a professor at the University of Salzburg. Unfortunately, he tells us, had to retire from this position due to age restrictions, and he now is a full professor at the University of Linz, and he's well equipped to present us with some developments from Austria. The final presentation will be held by Bart Krans. He's a professor of civil procedure law, private and procedural law at the University of Leiden. We have met up a couple of times, especially in Japan, which was quite interesting. It was an excellent presentation there. And we decided we'll continue to meet up, and we are quite lucky to welcome you, Bart, here in Göttingen. So you will present some thoughts on current developments under Dutch law. So we're really looking forward to the presentations. And as always, I have to mention that the presentation, the whole meeting is recorded and will be available on YouTube afterwards on my YouTube channel, der Zivilrechtskanal. You can download it there and re-access the discussion that is going on. And the meeting is also streamed live on YouTube platform, my YouTube channel. So if you want to take part in the discussion There are several ways to do that. First of all, if you're here in presence, you will have the easiest way. You just raise your hand and signal that you want to comment or ask a question, and I will note that down on my physical list. If you're taking part, I just let somebody else into the room, just not everybody outside. You will also, if you're joining the YouTube room, then YouTube stream, then you only have the possibility to use the top chat to comment on the presentations and to take part in the discussion. I will monitor the YouTube chat and will address your questions in the discussion here if it fits. And if you're taking part in the Zoom conference, then you know how to partake in the meeting. It's nothing new. You use the yellow hand function to signal that you're having a comment, or you use the chat to address your topics. So I'm really happy that we can start. We'll start right away with a presentation of Anna Nyland. The floor is yours. Thank you. To present. Just a brief note for the audience in this room. We have to remain strictly silent because on several places here on the table there are microphones, and if you chat, we will hear. So Anna, the floor is yours.
Thank you. I hope you can all hear me well. And it's really a pleasure to be invited here to speak today on the digitalization of civil proceedings. And I'm going to give you some examples from Norwegian law, because I know that even if it's more general, it's always interesting to hear something on Norwegian law. And what is the same in Norway, as I think after Bart and I did this research on COVID and civil courts and court proceedings, we can all say that many, or almost all, Western and even countries across the world had IT systems, but they were very much old-fashioned in most countries. And in this way, COVID-19 was a catalyst for producing digitization of civil proceedings and a leap into the digital world. What we don't know is to the extent to which these changes have actually been there, are still there now, and to what extent people have rolled back into the bad old habits, or some of them for maybe good old habits. I want to make a few points, and I'm going to talk about technology in society, about distorting discussions that get into the way of discussing technology, and also the path dependency of technological discussions. And then, I'm sorry, I will sound like the jinx, but I will talk about crisis preparedness, because I really think this is an important topic. So technology permeates our societies, and we have technology in use everywhere. And the Italian information technology expert, Stefano Quintarelli, he has said actually AI and artificial intelligence is a way to obscure what this is all about. And it renders the technology very opaque. So he then suggests this other term, systematic approaches to learning algorithms and machine.
Oh, somebody pushed the button, maybe?
Maybe? Could that be me?
No, please. Anyway, working.
Okay, so salami then, instead of AI, makes us really think differently about many things that have to do with this. And I'll just give you one example. For instance, if you can understand how ChatGPT works, this following example makes really sense to you. My son was watching Formula 1 with in English with translations to Norwegian. And you know, Lewis Hamilton, the famous Formula 1 driver, his abbreviation is HAM. And AI then turns ham into Schinke, and I know this works in German as well. And then Pierre Gasly, gas, is benzene in Norwegian. And if you cannot know how ChatGPT, for instance, works, then this makes very much sense to you, and you can understand that this is also very difficult to remedy, because this is how it is. It doesn't understand anything. It's just mathematical calculations. But do judges understand this? Are our civil proceedings shaped in a way that understand what this means? So, for instance, if you go to the bank and the bank tells you you cannot have a loan, and they have some kind of machine learning that points you out as a non-eligible customer, how can you then, if you then think that this system that they have is biased? Does the judge understand what kind of evidence you will need to prove this? Does the judge understand how this kind of systems work? Or another example, I was driving, going about maybe 80 kilometers per hour, and there was somebody on the bike, and this was the backpacker bike rider, and my car then interpreted this as another car, and suddenly started emergency braking, even though there was plenty of rooms and I could build room to overpass this cyclist and do it safely, and I could see that. So do judges understand it? And for instance, in countries like Norway that have very generous rules for access to evidence, so we have disclosure rules, would a judge allow you access to the relevant evidence? Would the judge, when the judge sees the evidence, understand when and who is liable? And of course, here I don't think this changes too much, even with substantive legislation, because there will still be issues around how this specific system works. And I think our civil procedural rules are not fit for this kinds of reality. That's already there. And another way of thinking about this is also all the number of documents that we produce every day, and how do you make access to these documents in a way that doesn't allow for too many fishing expeditions, that protects, for instance, trade secrets and so forth. So even this sort of handling the world as it is today, I think it's difficult for civil procedure rules as they are. So then going on to how sort of distorted thinking is that many of the discussions become polluted with ideas that have nothing to do with technology. And for instance, in Norway, we have an appellate system where the appellate proceedings are basically rehearing the case. And you will retake all the evidence, and believe me, there's lots of evidence in Norway. There's a joke saying that a hearing that takes 1 hour in Germany will take 1 day in Norway. And I think it might be exaggerated, but it gives you an idea. And we already more than 20, 30 years ago, there was saying that we need devices to record evidence in courtrooms. And 30 years on, we still don't have this in place. This was put in place in Sweden in the 80s and early 90s. So this is really not rocket science. But this discussion becomes distorted, recording the evidence just to have it so you can prove what the witness says if there's allegations that the witness says something else in appellate proceedings, or if the witness cannot participate in appellate proceedings. Then it becomes distorted with this idea that maybe we should reuse this to save money. So that the role of an appellate judge would be to listen or watch these tapes from lower courts. And of course, you cannot find an appellate judge who wants to listen and watch recorded proceedings and then call the witness again, because you might have an additional question. And in Norway, you can have additional new witnesses. So there will be no time savings whatsoever if you use the recordings. But these two discussions become enmeshed. So you cannot then discuss recordings as a way of securing evidence without then this distorting discussion that has to do with the need to reform appellate proceedings. And the reform of appellate proceedings is then one that has to do with how do you imagine the best way of getting the correct judgment and justice. So basic ideas about the judicial system. And this reaches up then to the need to think that what we need to think about technology is also not just what is this technology good for, but also to think that if this technology is the answer, what is then the problem it's going to solve, and what are the problems that it might create, and what are the problems that it won't resolve. So we can also have other examples, and one is the uncritical adoption of new technology. For instance, when we think about witnesses, in Norway, we have heard witnesses remotely, on telephone, for really a lot of time, and particularly expert witnesses. And what happens then is that now we can also add viewing, seeing the witness. But the problem is that psychological research tells us that it's easier to judge the credibility of a witness if you can just hear their voice, if you can't see them. And when we have these witnesses remotely, we don't know whether camera angle, lighting, background, distance from camera, and so forth, what they do with our perception of this witness. And we don't know whether this is the same for everybody, or might this be something that is not distorting when we hear an expert, but might be if we hear somebody who we generally would assign lower credibility to. And also, we don't know yet, as far as I know, how this technological distance, whether it also creates a psychological distance, and whether this is the same, again, in all types of proceedings. And also, we don't really understand how this presence or distance can be an advantage. For instance, if there's fear and animosity in the room, it could be an advantage. We know this from family mediation. That family mediators in high conflict families with violence, many of them say that they perceive distance or remote mediation as a better alternative. But this might be very different in a case, let's say, business partners who've known each other for a long time, and for whom being present in the same room might actually be very beneficial, and might then lead them to settle. And also, we don't know whether this distance, does it do anything with the feeling of justice? And we don't know whether this is the same across cultures. I know some of you might have seen pictures from Chinese online courts, these small avatars that look like cartoon figures. Would a European person, for instance, I think that many Norwegians would find that very odd way of having a court, and would probably then prefer written proceedings. But we don't know, we haven't done research, and we don't know whether this is the same in a tort case, in or a contract case, family case, and also whether the parties, if they know each other from earlier on or not. So these are things that we need sort of input from psychological research when designing legal rules and these systems. I would also want to point out that we are very much path dependent and technology dependent. Our current rules of civil procedure were founded in the late 1900s and early 20th century. It was a time when we could suddenly travel fairly long distances by train, and therefore it was natural that we should go from written proceedings, where you could just send a letter instead of traveling a very burdensome way to some other place. And then we also have proceedings that are actually for pen paper and typewriting. And these ideas still seem to guide the way we devise our case management systems and the way we structure proceedings. So, for instance, the old-fashioned Norwegian case management system, we have basically paperless courts. It doesn't allow putting in a table where you could have, in a complex case, so all the claims and amounts that are claimed, and that you could then update. So what happens then is that these numbers, they are available in documents become new version of these documents if the parties change, amend their claims, or if they settle something or withdraw a claim, and so forth. And this all becomes a mess. But the system doesn't allow for this, partly because it's old-fashioned technology, from technology-wise, but also because this is not the way we have conducted our civil proceedings. We have always given a new document, but not updated documents. And the same has to do with the way we fashion and structure our hearings. We think of hearings as quite burdensome because they require presence, so physical presence, but simultaneous for both parties. So synchronous and very temporal and tied to a specific location. And therefore we fancy this idea of concentration in hearings. Oh, technology allows us to go further from there and structure proceedings. And this is particularly could be an advantage if you have self-represented parties, or partially self-represented parties, which is the case sometimes in Norway, because then you could do it incrementally, and actually going away from this concentration idea could be okay. Also, today, I mean, you may have access to Teams, for instance, where you can co-author on a document, and it's quite normal, but we still haven't thought that our civil proceedings should be that concretely cooperative between the parties. And we haven't transferred what is already out there and ways of working that are already used in other domains into civil procedure. And this is also something we should think about, not only how these age-old ideas shape current rules, but also how there are new ways of working and how we could and should incorporate those into civil procedure law. And then there's also some other functions that we don't use yet. And that has to do with, for instance, if I comment on other people's writings, I put in comments in Word, but I would like to see a judge starting to work that way, that you would actually be able to pinpoint. And you could also ask the other party to pinpoint exactly, rather than to write their own paper and file in their own submissions, and then they start to talk past each other. Then you could build in these kind of functions, and this would also probably be very helpful for self-represented parties. And all of these things are possible. Some of them are not possible within the systems that we have, and some of them are not sort of technological systems that we have. Some of them are not possible because of the way we think. And some of them would actually be possible with new technology, but our thinking limits them. And then, of course, we need to know whether these are good or bad, whether we should incorporate them, or whether we should not do that, whether they could then actually help us or not help us to have more expedient and more accessible and even better results in our proceedings. So we need to see what is the potential, but also what kind of principles would we like our proceedings to rely on. Then moving to my final point, and this is the crisis preparedness. And I know I'm sort of feeling like I'm becoming the jinx here, the one who brings the bad news. But the thing is, and if we look at the world around us, we know that technology is vulnerable. We know that there are power outages, hacking, jamming, internet cables that could be damaged in some way. But we also know flooding, heat waves, and even electromagnetic solar impulses. Yesterday, as northern lights across all of Norway, but they could actually also destroy our infrastructure. And people who work on aircraft and vessels, and people in hospitals, they practice every day or regularly for instance, for cardiac arrests. What do you do then? You can't start to look in the manual. And I would like to see judges practicing this. I would like to see a group of judges and lawyers who are set up for a mock day, regular day at court, and 6:30 a.m. they got this message: you have a power outage, and you cannot cancel the case. You can postpone it by 2 hours, the hearing. And to see, then they would have to figure out how to run the court that one day. Or another group at another court could have, the task would be, you have no internet. How do you manage to get through a day? And they would also be told, there will be no internet. You have to imagine yourself in a situation, there will be no internet for the next 2 weeks. And the power outage, you have 2 hours just to charge your phone every day. How do you proceed now? And I think if you would harvest the ways, their solutions or the way of thinking that they find during the single day, I think we would be able to create much more prepared systems that would be much better and safer for the use of technology. So I think we should embrace technology very much, but do it very critically, and to think which parts of this should we incorporate and how do we do it in a way that suits different kind of cases, because there might not be a one-size-fits-all after all. Thank you.
Thank you very much, Anna, for the many thoughts on how to approach digitalization. There were a couple of issues we can touch on, or I'm keen on touching on later in the discussion. We always have the discussion at the end of the presentations to focus the discussion on one spot in the online meeting. So if you have questions on Anna's presentation, so please note them down and don't forget them. So we start right away with an Austrian couple presenting on the new developments in Austria on digitalization. I think Professor Neumeier will start. So the slides are there. Professor Neumeier, you've got the floor.
Okay, thank you, dear colleagues. Thank you very much for the honorable invitation to contribute to the Göttinger Kolloquien. Unfortunately, both Thomas Gaber and I are currently suffering from health problems. I myself are currently in the hospital. You can see it probably from my background. Now to my topic, the digitization of Austrian civil procedure, or seen from a somehow historic perspective. I will give you some examples. Austria has been a pioneer in the use of modern technologies in civil proceedings, here understood in a broad sense. In the early 1970s, preparations began to transfer the manually maintained paper-based land register at the district courts to an electronic database system. The actual transition started in 1980 and was completed in 1992. The transition of the commercial register, which is also kept by courts in Austria, into an electronic database took place from 1991 to 1994. And since 2006, the deed collections for the land register and the commercial register have been maintained electronically. These electronic database systems do not only facilitate data retrieval, documents can now be accessed via the internet, but they also contribute significantly to the Austrian state budget. The self-financing rate of courts in Austria is around 100%, and the main sources of income are from land register and commercial register inquiries. The transition of the land register had a positive side effect on further development. It connected all courts in Austria via data lines. This was relatively easy to achieve as all ordinary courts in Austria are federal courts. The term ordinary courts is found in the Austrian constitution and distinguishes the courts that essentially deal with civil and criminal law from the administrative courts. Unlike in Germany or Switzerland, Austria's ordinary judiciary doesn't have courts at the state or canton level. The early implementation of court-to-court electronic communication via secure data lines significantly facilitated electronic case files and electronic legal correspondence. And I will deal with this special topic of electronic legal correspondence briefly a little later. A small detail to note in this context, since the 2004 amendment of the Civil Procedure Code, the possibility of conducting a video conference instead of a witness examination by a requested judge has been provided in court proceedings. Specifically, Article 277 of the Civil Procedure Code now states, I quote, that the court must conduct an immediate examination using technical facilities for the transmission of words and images according to the technical possibilities instead of an examination by a requested judge. A video conferencing quickly gained practical significance in Austrian civil proceedings, but only instead of a requested judge. By 2011, all courts were equipped with the necessary facilities. And here are a couple of statistics from before the onset of the COVID-19 pandemics. In 2019, approximately 4,500 video conferences were conducted nationwide, with about 11% of them being cross-border. It is important to note that the person being examined does not join the proceedings from home through video. Instead, he or she is required to go to the nearest district court from where he or she is connected. An independent room reservation system was developed, allowing the court conducting the hearing to reserve and block the video conference room at the district court where the witness is being examined. A prevalent view among the judiciary is that the person being examined should come to a court rather than having the witness examination take place from the comfort of his or her home. Now turning to the electronic legal correspondence. In 1990, this in German called elektronischer Rechtsverkehr was introduced as a means of communication between the courts and party representatives alongside traditional paper submissions. Austria was the first country in the world to establish electronic legal correspondence. This electronic legal correspondence is particularly useful for the direct transfer of data in the payment order procedure, which plays a major role in Austrian civil proceedings. Since 1999, service of documents from the courts to the party representatives has also been carried out by electronic legal correspondence. This measure has saved the judiciary substantial postage costs, with the Federal Ministry of Justice estimating annual savings of approximately 12 million euros. The success of electronic legal correspondence is primarily due to the mandatory participation for certain professional groups, starting with party representatives as attorneys and public notaries, and later extending to include banks, insurance companies, social security institutions, experts, etc. Although the aspect I'm going to mention now is not directly related to the ordinary judiciary, but rather to the administration, it is worth mentioning because it significantly simplifies the work of the courts. The Central Residence Register, ZMR, Thomas, I think it's the side one. Yes. Established in 2002, it serves as the primary administrative register and as a foundation for many public administration tasks, as elections, for instance. All election data is updated promptly by the registration authorities and made immediately accessible in the ZMR for inquiries. This is vital for the work of courts, as all authorities, as well as banks, insurance companies, attorneys, notaries, and others verified by the Minister of the Interior, can access it online. Since it is mandatory in Austria to report changes of residence, court service runs relatively smoothly this largely eliminates the need for extensive work with absentia, curators, and civil proceedings, as was common in neighboring countries like the Czech Republic. Of particular importance to the judge's day-to-day work is the Federal Legal Information System, in German Rechtsinformation, or abbreviated REIS. This database system consists of several interconnected sub-databases with a similar structure. These databases have been accessible over the internet since 1997. The sub-database with the most frequent usage is federal law. Can I give you an example? It concerns Article 933 of the General Civil Code. Slow internet in Graz.
Can you see it?
No, we cannot see it until now. You need to change the screen.
Okay.
You share to your browser.
It doesn't know how to do it now.
But you can see it on your screen.
You just have to use the share screen button and just select the browser window, and you can see. Yes.
Okay. So you have to use a keyboard.
I try again. Sorry.
ABGB and 933. This rule is part of warranty, contractual warranty law. The title is warranty period and limitation period. I see that this rule has been in force since 2022. If I want to see the previous version, I can change the query date. So might be you go one slide back, zurück zur Suche. Okay. Yes. Okay. It's the easier way. Thank you. So this was the version from 2001 on. Yes, there's been a... So if you go a bit down, you can see in this older version that the title has changed. So this was an earlier version. So it's quite easy to work with. The next most... so we have to go back to our slides. Okay, thank you. The next most frequently used subdatabase is Justiz, which contains decisions from the Supreme Court and some lower courts, as well as decisions from the European Court of Human Rights. What makes Justiz unique is the headnote database. Starting in 1907, the essential statements from Supreme Court decisions were recorded and updated on index cards by the so-called Evidenzbüro of the Supreme Court. A system of references was developed to indicate how a recent decision is related to previous ones, ranging from identical and similar to different and explicitly contrary. The number of index cards has increased to more than 300,000 until 1996, and from 1994 to 1996, the contents of these index cards were transferred to an electronic database. These headnotes, which are updated on an ongoing basis, are now freely accessible on the internet. I would like to illustrate this with an example. It concerns decisions on electronic legal correspondence. Okay, you see a number of decisions of the Supreme Court. If you go down a bit in an initial decision in 2029, the Supreme Court stated that it is necessary to name the correct court in submissions in electronic legal correspondence, although all submissions first end up at the Federal Computing Center in Vienna. In the following, you can see how the case law has developed very uniformly here. With one click, you can access the full text of the decision. Thomas, might be you take the one of them. Okay, yes. So this is the full text of a very short decision. You can also see the original of the decision as a PDF, if you want. But we can go back to save time. Okay, next slide, please. In Austria, there's an ongoing demand to make the decisions of not only the Supreme Court, but also those of all courts publicly accessible via the internet. I cannot deny that I have significant concerns about this. I can give you a brief selection of my main arguments. A straightforward issue is that the database would become overloaded, making it more challenging to navigate as the number of decisions grows. The answering of legal questions by lower courts is of little general interest. I presume that there are other interests behind the call for universal publication, mainly interests of facts and consideration of evidence. And it is relatively easy to, so I have to pronounce the word correctly, pseudonymize a decision from a higher court, and this is hardly the case for a decision from a lower court. To pseudonymize such a decision would require considerable effort. For example, the names of witnesses are mentioned. Okay, this is easy, but also whether the judge believes them or not. This is not it might be very interesting for a public view, but I don't know if you want such a development. I feel that it is about judge profiling, even if this is always denied. Moreover, I am concerned that the knowledge that the decision is permanently and publicly accessible might alter the way a first instance judge composes the judgment regarding the facts and consideration of evidence. So far, I see no convincing advantages of a universal publication of all judgments. So I have now used up a lot of time with my historical review, and I can now hand over the microphone to Thomas Graz. Thank you.
Thank you, Matthias, and thank you, Philip, for inviting us. I would like to discuss the topic of video hearings under section 132A of the Austrian Code of Civil Procedure. This topic is of particular importance as it allows for legal proceeding to be conducted in a digital format. Firstly, section 132A of the Austrian Code of Civil Procedure is closely aligned with section 3 of the first COVID-19 Judiciary Relief Act. This means that the conditions for holding a video hearing under section 132A are largely the same. To conduct a video hearing, certain conditions must be met: a court-ordered video hearing, the consent of the involved party, and the availability of the necessary video conferencing technology. Additionally, the use of audiovisual proceeding must be considered from an efficiency standpoint. A question that arose during the development of video hearings in 2020 and 2021 was how the general public could access these proceedings in line with constitutional and human rights requirements. To address this, the decision-making body cannot participate in the hearing via video technology. Consequently, at least the judge is required to be physically present in the courtroom during a video hearing. The decision to conduct a video hearing is at the discretion of the court. Parties can only make suggestions in this regard. The use of audiovisual proceeding must align with the principle of procedural efficiency. The court should also consider the technical requirements, ensuring that the courtroom is equipped with the necessary technical facilities to allow the public to follow the proceeding both visually and acoustically. A video hearing can only proceed with the consent of the involved parties. Parties' consent to a video hearing is assumed if they do not object to the video hearing order within a reasonable time set by the court. This period is either specified in the hearing notice or established through a separate order. An objection from a party does not require justification and results in the exclusion from the hearing conducted via video technology. Only one party objects to virtual participation. Hybrid hearings are possible where only one party participates via video conference. In terms of evidence collection during a video hearing, certain limitations apply. Video evidence collection is restricted to the examination of parties or informed individuals as witnesses and the presentation or discussion of expert opinions. Furthermore, audiovisual examination of parties is limited to the first hearing. Document-based evidence and visual inspection evidence are generally unsuitable for video technology. These limitations seem reasonable. But it's questionable why the examination of the parties is only permitted in the first hearing. The focus should be on whether the specific type of the evidence is generally suitable for video technology or not. The limitation is not convincing. In the context of video hearing, it's crucial to address the potential challenges arising from technical issues or connection problems, as this can significantly impact the proceeding. When such issues occur, it's important to consider the legal ramification or the remedies. Technical failures or connection problems that prevent a party's timely participation in the video hearing typically lead to assumption of a judgment based on the default of the party. In other words, if a party is unable to attend the video hearing because of technical issues, the court may proceed with the case of its as if the absent party had failed to appear. To mitigate the impact of technical failures, the legal framework provides for certain measures. Firstly, it's possible to extend the video hearing. The extension can be requested by a party or granted by the court ex officio. Such an extension may be justified in cases where a video conference does not start on time or when there's more prolonged disruption of the. When a technical issue or connection problem arises, is the responsibility of the party to inform the court promptly. If an extension of the video hearing is not possible and default consequences occur, the defaulting party generally has the option of seeking reinstatement. Reinstatement allows the defaulting party to request that they be placed back in the position they were in before the default occurred. However, it's important to be aware that seeking reinstatement may have cost implications. In some cases, particularly in specific areas of civil procedural law, such as insolvency and enforcement proceeding, reinstatement may not be an available remedy. In conclusion, technical failures and connection problems during video hearings can have significant legal implications. So, thank you very much for your attention.
Yes, thank you very much, Thomas, and thank you, Professor Neumeier, for presenting, and especially thank you very much, Professor Neumeier, for joining us out of the hospital, which is which we really appreciate that you are taking from there. And now we just go on with the presentation of Bart Krantz, and we'll hear something about the developments in the Netherlands. We're just setting up the scene inside here, and you might see it already on the screen at home.
for open discussion.
Yeah, it was open for
Thank you very much. Thank you very much, dear Philip, for this very kind invitation to this beautiful university and this very well organized, once again, colloquium. A pleasure to be here. What will I try to speak about? Some developments from the Netherlands. A major digitization project for civil proceedings, which almost entirely failed. And the principle of public justice and digitization on civil proceedings. And don't worry, this looks like a very balanced menu for a presentation. This looks like a very fair menu for a presentation. It's not. It's not balanced and it's not fair. I will try to tell you why it's not balanced and why it's not fair. And we will come to that, but don't worry, I will keep my track of my watch. I will try to end just before sunrise. And if I speak too long, I trust that Peter will push the button and give me a sign. Why am I telling you this is not fair and this is unbalanced? That's simply a way of expectation management in a very short because it's a bit extra. What will I do? Let's talk about a major digitization project in the Netherlands, which almost entirely failed, and this is not a joke. Since 2017, proceedings in the Netherlands before the Dutch Supreme Court are digitized. They are fully digitized proceedings in cassation, so just before the Dutch Supreme Court, they're digitized. The Dutch Supreme Court has their own online system, there's their own online system. Lawyers who are proceeding in cassation, they know their regime, but it does not apply to lower courts, to courts in first instance and court in appeal. We have a three-tier system as in most countries. So lower courts do not have a digitized system. In 2013, so almost 10 years ago, it was decided to start a digitization project, a serious project on digitization. A huge project was set up. It was not meant as a tiny project now, that it was, at least to say it was ambitious. It was really ambitious. The name of the project, short abbreviation in Dutch, was K. And K, it's the Dutch abbreviation for quality and innovation. Kwaliteit en innovatie, quality and innovation. So everybody knows the project in the Netherlands is K. K is also the Dutch word for stone. I don't know why. Quality and innovation. K was really ambitious. It tried to dignitize and to modernize civil proceedings entirely. The intention was not only to simplify the civil proceedings, which are quite simple in itself already, but also to unify pre-existing forms of civil procedure. Just to give you one example of the ambition of the project, as in many, many countries, there are several types of civil proceedings in the Netherlands. We have civil proceedings on, let's say, commercial cases, but also civil proceedings in family law cases and insolvency cases. They have their different regimes. Procedural regimes in commercial cases are not the same as procedural regimes in family law cases and insolvency cases. There's a serious distinction between decades and decades. One of the goals of this project was to harmonize it all. To harmonize it all and let us design one size fits all, as Anna Newland said, let's try it, be aware of one size, let's try to get rid of all these distinctions. Let's make one example of how to digitize civil proceedings. Let's make also it possible that all the variations which could happen in civil proceedings could be part of this new online system involving third parties. All the entanglement concerning evidence, joiner, intervention, indemnification, it should all be part of this system. So all the variations which one can think of in civil proceedings should be able, the new system should be handled to enable all these variations. So it was really ambitious. At first, when the project was set up, the costs of the ICT project were budgeted at around 7 million euros. 7 million euros. The train started and the train started rolling. And somebody said, will this work? Are you quite sure that the ICT can handle it? Yes, it will work. Okay, perhaps a bit more than 7 million, but it will work. It will work. The legislation to make this possible was prepared. Not just prepared, seriously prepared. Legislation was brought before Parliament to make the enactment possible. Serious, but not all lengthy debate in the second chamber. First chamber, so it passed Parliament. It passed Parliament, some amendments here and there, but it passed. I cannot say with flying colours, but the legislation process was almost over. Not almost over. It passed. It was also put in the official journal in the Netherlands. Now this can be enacted. There's only one thing which had to be determined: the date of enactment. So it was put there. Just one push on the button. Let's start on January 1. Year not determined. So the only thing which was not determined yet was the date of enactment. Why not? Because the technical problems kept piling up and piling up and piling up. The ICT turned out to be more complicated. There were more warnings. Will it work? Will it work? How it will work? Let's start 2 district counters in the Netherlands as a pilot. Midden-Nederland and Gelderland, 2 regions in the Netherlands, started the district courts started to use it in the pilot. Costs start adding up and adding up. There was no date for them. But the parliamentary process, the legislative process, was entirely filled. Just the date had to be entered. In 2019, the Ministry of Justice said, well, this is getting out of control. At that time, the cost had amounted to more than 200 million euros. It started at 7, it costed 200 million euros. And then somebody pushed the button stop. The legislation process was already finished, just the date of enactment was not there yet. And then we had to start a new legislation project to repeal this act. This repeal act was brought to Parliament. At that time, costs were over 220 million euros. And it didn't work. The system simply did not work. It was too ambitious, it wanted too much. So the act to repeal it, that was quite easy. To repeal it, a bit more complicated, not to repeal it, but to formally it was, we make a reset. We make a reset and we try it again. And the main point of the repeal act, as we call it in the Netherlands, the stop act, as it's referred to, stop quality and innovation, let's do a reset. It was not entirely say we will not go forward. No, we must do it step by step, not too ambitious all at once. So what we're doing now, we're facing the situation that is 220 million euros, which came from the budget, the regular budget of the Dutch judiciary, the budget where courthouses and lawyers are paid for. So this is a serious amount of money. I don't know the percentage based on what it is. So this is too much, now we stop. It does not work. At that point, we said, let's try again, back to the drawing table, and now step by step, see what we're going to do. So this is the situation in the Netherlands, and perhaps one of the lessons which can be learned from this really copy project is not too ambitious at once. It doesn't mean we're stopping digitization. No, we're not stopping it, but we're doing it one by one. The focus is now more on digital accessibility instead of digitizing proceedings at all. So digitizing accessibility, perhaps some online hearings, perhaps some online delivering of accidents, but not the entire process digitizing at all. That ambition has been stopped for now. So that's the first part of what I wanted to talk about. And preparing this presentation, it inspired me to dig it up and as a follow-up on, let's say, the KEI debacle, what happened in KEI, the Quality and Innovation Project, fundamental rights, civil proceedings. Why did I tell you this was not a balanced presentation? I'm hopping from one topic to another, and I'm trying to make a bridge which isn't there. So trying to see what's the next one. If we try to digitize, and we still are, but now in the Netherlands we still are, but step by step, one of the main points is let's not forget the fundamental rights. And what I want to talk fundamental rights on 2 topics: online hearings and the public aspect. The public aspects on online hearings. Why those 2? Because in the last years, since 2022 and this year, we had 2 decisions from the Dutch Supreme Court on this topic. Let's see. Let's start with the first one from April last year. So not this year, but last year. What happened in April last year? What happened over there? In this case, an oral hearing took place. An oral hearing in pandemic times. The oral hearing took place, let's say, I think it was somewhere in summer 2020. So in digital, in pandemic times, an oral hearing took place. Not a physical one. I will spare you the substantive legal dispute. I will spare you the details because the case reaches the Supreme Court. And the only question the Supreme Court had to rule on was, in this case, an online hearing. Was it allowed? And 2 elements were in particular brought to the attention of the Supreme Court: publicity of the administration of justice and the right of parties to an oral hearing. In this case, the right of parties to an oral hearing. There were complaints. Thomas Garber already spoke about it. There were complaints about the oral hearing in this topic because there were technical issues. The oral hearing had taken place, but there were technical issues with the connection, with the interruption, and one part said there were so many technical issues. My right of access to the online hearing was in fact violated. It was in fact violated because of too many technical issues. And it may concern the degree of speaking time, the ability to respond on scaffolding or on pieces. In practice, a lot can go wrong. These kind of technical problems, at least in the Netherlands, unfortunately, they're not uncommon. But they're there, and there's it's a good reason that we are spoken about it already. It may very well turn out to be difficult to establish what went wrong. At the same time, the time set for the oral hearing can be really limited. So there may be some tension for the future between procedural economy and the right to be heard on both ways. It must be made sure in some way that the right to be heard on both ways is taken seriously. It did not come to a decision from the Supreme Court on this topic. I will spare the details, it's rather technical on cassation matters. The Supreme Court in this case only decided that in this pandemic times, and the specific circumstances, a digital hearing was acceptable. What went wrong and what were the flaws that went wrong, that's up to the lower courts to decide. Perhaps there will be follow-up case law on it, but this time, it makes sense. The time when physical contact, physical presence was almost forbidden, of course, in some cases, digital hearings should be made there. And then the right of public access to justice. The right of public access to justice in the same decision. I will track time, don't worry about it. Access to justice includes a lot of things, public access to hearings. And the importance of openness, of course, is there. It lies in the controllability of the justice by the public. Publicity contributes to public confidence in judiciary, that's made clear. At the same time, public access is not unlimited. The end of 2020, so almost 3 years ago, the Dutch Supreme Court already ruled not being able to access a physical hearing in a physical room does not take away the character of the public character of a hearing. If the public can follow a hearing by other channels, that may be ground for public for complying with public rules as well. And that makes sense. Digital accessibility to hearings makes it possible for those interested in the treatment to follow. And several authors have welcomed in the Netherlands, have welcomed the openness of live streams, and even in some cases, judiciary promotes the use of live streams. Promotes the use of live streams and is actively doing so, for example, via LinkedIn, etc. And is argued that following hearings online should be made possible in more cases. And the argument is, well, the hearing may in theory be public, but in practice this means little. And I don't know if there's any connection with this line of reasoning among certain scholars, but the public nature of civil proceedings becomes more and more prominent in the last case I want to deal with. Because this one from 2022, I was just seemed to be the, let's say, appetizer or paving the road for the major one from just a couple of months ago. And I think this decision was even taken after we decided to set up, you decided to set up this colloquium. So let's say a fresh one, relatively fresh one. What is it about? Third parties and information on pending civil cases. This is considered a big one in the Netherlands. What is it about? This result from this decision from April. It did not concern ordinary proceedings in cassation, but a so-called, what we call in the Netherlands, cassation proceedings in the interest of the law. In the interest of the law. That means the case had gone up to first instance, to second instance, but there was no appeal lodged to the Dutch Supreme Court. So the case, the decision from the Court of Appeal in second instance had become res judicata. Res judicata was already there. The Dutch civil procedure law offers a mechanism. If a decision has res judicata, there will be a possibility, an option to apply cassation, to appeal the cassation in the interest of the law. If there is a matter in the interest of the law, you can lodge it. If there is a problem, you lodge it to the Supreme Court. If somebody wants to have an answer on a very important matter. That's what happened. The Attorney General to the Supreme Court lodged the appeal. The appeal cannot make the position of the parties better or worse, but just taking there is a question at hand which needs to be answered for, let's say, for the public character. That's what's called cassation of the law. What was the case about? A lawyer had asked the registrar of the District Court of The Hague to inform him whether any proceedings between certain parties are or were pending before the court. So he mentioned the party and said, please, Mr. or Mrs. Registrar, can you inform me whether on this party some proceedings are pending? And the registrar of the District Court in The Hague refused. Simply pushed on the red button, said no. Why not? Because the registrar said there's no specific request for a copy of this and this judgment. You do not mention an ACLI number, you just ask for a party and give me all there is. And the court registrar said no, that's not specific enough. That lawyer started proceedings, summary proceedings, and the court in first instance, the summary proceedings, gave two decisions. He granted the request to provide copies of all judgments to which this party, which this person was a party. Said if you mention party A, you must provide all the decisions with party A. But he did not grant the request to give all pending proceedings. That's what the court in first instance made that distinction. This was taken up to the Supreme Court. Why was it taken up to the Supreme Court in the interest of the law? Because it turns out that there are severe distinctions, severe variations between the various district courts in the Netherlands. I guess if you would ask the registrar of the court in The Hague, the answer would not be exactly the same if you would ask the registrar of the court in Amsterdam, or Rotterdam, or Utrecht, or Groningen. My guess is that the district courts would not give exactly the same answer. Some kind of uniformity may be good. So what did they decide to do? To go to uniformity. The Dutch Supreme Court ruled on the topic, and ruled on this topic. They took the opportunity to give 7 decisions. I will not deal with all the 7, no worries. I know I'm the last word between you and beer. Discussion. So I will not go into it. But only one aspect I'll leave. They took the opportunity to give 7 decisions on the public aspect of fundamental right of digital proceedings. Because why am I mentioning those 2 decisions? They mainly apply, not mainly, but also apply to digital proceedings. And the main one is that the Dutch Supreme Court makes a distinction between 3 aspects on the public character of civil proceedings. Providing information on access to public hearings, providing information on access to public hearings, providing judgment, and providing other information such as pending cases. So, access to public hearings, providing judgment, and providing information on pending proceedings. I've not heard many scholars about the online aspect in Ireland, but I think there is there's a vast line of reasoning underneath. The Dutch Supreme Court starts with referring to Strasbourg. Extensive referring to Strasbourg, of course, Article 6. Article 6 of the European Convention is mentioned extensively. What does Article 6 mean in this aspect for civil proceedings? The Dutch Supreme Court says, well, district courts are required to provide timely information, to any person requesting it about place and time of public hearing. Any person requesting information about place and time of public hearing, indicating the cases that will be heard at that hearing, the names of the judges hearing it, except for, let's say, privacy rules. They go extensively into privacy rules, they deliberate on privacy rules. So, and the Supreme Court explicitly adds, in case of an online hearing, courts are also required to provide information about the method of accessibility, about the mechanism of accessibility. So information on online hearing must be provided. Providing the judgment is pronounced in public. The judgment are in the Netherlands, not all, but the vast majority of judgment is published on the formal website of the judiciary. It's published on the formal website. But still, if it's not, look at my words and I'll wrap up. If it's not, even if it's on that website, parties and even third parties can ask for a judgment on a case which has already been handled with. Providing on pending cases, that's the piece of the main part of this position of April 2023. On this point, there's an interesting aspect concerning digitization of civil proceedings. Because when the civil proceedings take place digitally, there may be less public character before. Because on the introduction, there were docket sessions. Docket sessions where only administrative decisions were taking place. Those docket sessions, in theory, everybody could attend. But when it's digitized, nobody will be there. So the strange effect may occur that these docket sessions, they're no longer public, no longer have a public character, although the system is more digitized, because it's only the lawyers who have access to that system. So there may be a contradiction in that system. What does the Supreme Court say? The Supreme Court says the public principle of access to justice must be made, must be turned out in such a way that the list of cases to be heard in the court should be available for all. Should be available for all to consult. And this means, the Dutch Supreme Court, I'm quoting and translated, the current practice on public character of civil cases is therefore not correct in the Netherlands. And they do not stop there. They say it's not correct, but they also give an indication of what should happen next. It's up to the courts. We suggested the lower courts, so that's the Supreme Court state, to make nationally uniform national arrangements on this point, for example, in the form of procedural rules, also including the public character on docket sessions and online hearings. There's ample attention in this decision for privacy regulations. I will not go into that. It's quite clear that civil proceedings also entail aspects of fundamental rights. In conclusion, perhaps if you said the kei woordje, which is almost entirely filled, do not be too ambitious at once. Digitization entails new questions on the public principle, public justice. Fundamental rights must be taken seriously, and it's almost impossible to leave Göttingen without quoting eine. Because what did he tell us? He told us, he made us clear that there is a relation between jokes and civil law. Because if I'm told and if I'm informed correctly, he told us once that jokes and creditors should not announce their arrival too soon. Thank you very much for your attention.
Thank you, Bart, for the excellent presentation and on the developments in the Netherlands. I think we now turn to the discussion. We've got some time left, so we'll discuss until think we have finished. So we don't have to stop at 6:30. We can go on a bit in our time schedule. If you wanted to partake in the discussion and address your question in the Zoom room, then just use the possibilities you already know, and the same applies to the discussion, to partake in the discussion in the YouTube stream. And for questions or comments in this room, you know how to address yourself. Are there any questions from your side? Not yet, at least. So I will just start the discussion with some questions I've noted down. And the first thing I want, or I'm interested in, concerns Anna's presentation. You've said that considering the developments of this digitalization measures in civil procedure law is dependent highly on the acceptance of the digital means by the involved parties. So, as people are quite different, people may have certain favors. Some like to address their topics a bit more by digital means. Some others rather like addressing their position in paper or in person. How do you think we shall cope with these differences and maybe also a digital divide between people who are not so familiar with digital means of communication and those who are? How shall we approach this? And the second question is concerning the technology dependency we have. What do we think will be a good advice for German lawmakers to address or approach digitalization measures? As you know, we've got the German Föderalismus. We have a couple of lawmakers involved in setting up the justice administrations. Even though the civil procedure is a federal law, the administrations are business of the Länder, the German Länder. And so what would be a good advice to achieve a good outcome in digitalization? Or at least from your perspective.
Thank you. I think when it comes to sort of acceptance of digitalization, that you have to, of course, you cannot go on an individual basis very much, I think. Of course, to some extent, you could do that. But for instance, in Norway, we have rules that one party cannot stop a remote hearing or remote examination of a witness unless there is a good reason for doing so. So like a week ago, we had a spell of really bad weather around the Oslo region. So that would be a day when you would say that there would be quite a high threshold not to hear a witness online, simply because due to the weather conditions, you cannot travel. But I think, I mean, across countries and across groups of cases or party constellations, you could do that. And I think if you compare Scandinavia in general and Germany, you see that we have quite different approaches to technology. And I think that the legislators and judges have to take that into account, that whereas sort of people in Scandinavia and Norway would say that if you don't have a digital court, then there's something wrong with the court, or that's something, why are they so old-fashioned that this cannot be good? And then at least my impression, sort of the Germans are more hesitant. For better and worse, it goes, I think, both ways, but you have to take that into account, and also different kinds of cases. But we know I need more information. We need more knowledge to make, if you want to make different rules for different situations. And of course, we have to mind the digital divide. But when we did a book, I think there was, for instance, they had these Zoom rooms in Singapore. So it could be a place where you could go and actually then like have a room where you could sit and be online. You could have places where you can then go and get assistance, and you could even have devices, because we know many people, poor people, they only have their telephones, and maybe not really too much in Scandinavia, but elsewhere still rely on the mobile net rather than having high speed at their home and so forth. And as for sort of giving advice, I feel I'm not really in the position to in this federal system, but I think there is one thing that's good with the federal system, is that you can actually, you have these sandboxes of the lender, and some of them could be sort of more willing and to test something out, and some could be they could test different things and then cross-fertilize, whereas in a small country often you cannot do that, and also learning across courts becomes difficult because we don't have a system to put that in place. But thank you for a difficult question. I don't think I can give a better answer than that.
No, that was a very learned answer, and this, especially considering the Nordic countries. You may have some elements of cooperation there as well. And is that the case, that you exchange your views, for example, in Nordisk on digitalization issues there as well?
Well, we have different kinds of sort of formal and informal cooperation, but yes, ideas travel. And for instance, I've done Nordic Association for Procedural Law meetings. Then we discuss digitization, and often, of course, because the countries are quite similar populations and similar in their acceptance of and the existence, for instance, that everybody basically has high-speed internet in their home, and that has to do with what can you expect for during COVID judges to do from their homes and parties to do. So yes, that makes it much easier to exchange ideas. But of course, having said that, we actually lag behind the Baltic states. So they're even some of them, especially Estonia, is much more digital.
Yeah, thank you very much. I've got Bart on the list and then Volker.
After you, I've had the floor already. Okay. First of all, just a remark. When I'm not doing proper procedural law, I'm in the field of ethics and sitting with the German Ethics Council, and we had quite a similar debate on a huge opinion we published last year, which is called Man and Machine. It's about artificial intelligence and much in line with your do not speak about AI, speak about salami. And this is really also the bottom line of this very long opinion, that we should not take these phrases for the substance. So it's not intelligence in the sense we speak about intelligence. Let's have a closer look, and I'm very much agree with four of the presenters that we also have to look what our fundamental guarantees and procedural principles are. And one thing is, and that's the question for you, Anna. You just mentioned it. Is a digitalized civil procedure really a civil procedure for everybody? Yeah, even in Scandinavia, where maybe technology and high-speed internet is available for most, is it actually available for everybody? First part, or are there? We take long ways to include people with several disabilities, vulnerabilities in our standard traditional way of civil procedure. And I haven't read and heard much about attempts to do that in a kind of digital version. This seems to be not in the focus of the fans of digitalization. For our Austrian colleagues online, I do hope that I can be heard by you well. The issue Bob spoke about, publicity of hearing. How do you deal with that in these Austrian video hearings, video witness conferencing? How do you provide for that? That would be maybe a more practical, but also a very principled question, because Article 6 of the European Convention on Human Rights is also important for Austria, as we all know. So, how do you deal with that? And first and last but not least, to you, Bart, is it really the same type of publicity if you just video stream everything? Or doesn't it change publicity as such? Thanks.
If I start with accessibility, actually there is research from the US. I think he's called David Larson, who is a professor at Mitchell Hamline Law School, has done this research. He has done it also on other accessibility issues, and there's also I think she's called Amy Schultz or something like that, Schmitz, I think, who has also written on the digital divide, and has, I think, very nice articles. But I absolutely agree that in the European debate these voices are absent.
Perhaps our colleagues online want to react to the Austrian question.
During the pandemic, it was very difficult for the public to join the judge. but now the judge has to be physical in the courtroom, and the public can go to the courtroom and join it.
So
you would not accept
publicity is not digital; it's physical.
Yes, for the judge and the public is physical. Only the parties can join via video hearing.
Just as an addition to this, has there been a discussion when enacting what was it, the article or paragraph 132A? Was there a discussion going on about whether to provide for live streams and enable a digital presence and how to cope with personality rights, data protection, and things like that? Was there a discussion going on in Austria?
Yes, huge discussion about this question, but different solutions. But now Section 132A says that the judge has to be physical in the courtroom, and the public can go to the courtroom.
Okay, Clark.
Thank you, Volker, for an intriguing question. My answer would be two-sided. Online is not the same as physical. An online hearing is not the same as a hearing in a courtroom. And it applies for lawyers, for parties, but also for the judge. I can imagine for a judge, it's really different. Only you listen to a voice, Anna already spoke about the example, or looking the witness in the eye. Looking the witness in the eye in the room and seeing how he reacts, and for the parties to see who the judge is and see who the judge reacts, may be very difficult than just an online hearing. So for hearings, there's a huge difference. For access, it may be also two-sided, because being in a room, publicity on being in a room is different than publicity just online. But perhaps during the pandemic, we noticed that more people could attend hearings online than people would have attended a courtroom. So it's a different way of publicity, but it may turn out to be the case. I'm not promoting it, but just trying to establish what's going on, that online presence enables more people to be there than by the boundaries of the size of a courtroom. So it's a different size of publicity, different type of publicity, but it may turn out to be more publicity in the end. I'm not quite sure what the final answer will be, but thank you for these thoughts.
Well, the final answer would be, it depends. Because
it's always a private law.
Yeah, maybe if you allow. So that would be an argument to broadcast everything that is happening physically via TV as well, if I follow your line of argument at the second part. So if we video stream everything which is happening online, we could also broadcast everything which is happening in the courtroom. And I think there are some arguments against that.
Sure.
And maybe they apply to the online system as well.
Exactly. The arguments which are there for physical hearings attending would apply to online hearings as well, especially the GDPR and privacy rules. They play an important role. That makes sense. But at the same time, that it's argued very much, at least in the Netherlands, there should be much more openness and much more online hearings. Where that's a good line of reasoning, I'm not quite sure, but we see there's a tendency to in that direction. But privacy rules, well, let's take them serious.
But I'm not speaking only about privacy rules. My question is directed to whether there are procedural reasons for not doing that. And that's what my question was, whether it does change the type of proceedings or the character of the proceedings as such. So this is a procedural argument, not a privacy right argument.
And I would say that this was during the pandemic a discussion in Norway, and what happened was that Norwegian courts started to limit the number of seats in the courtroom by saying that only so and so many people could sign up to watch the online streaming. And of course, one person, you could gather a group of friends and family and invite all your neighbors, although I very much doubt it. And this sort of, that it's not for the general public, particularly in lower courts where you have witnesses, where you have parties who then start to present. And this is very different nowadays. The Supreme Court streams some of its hearings, and Volker, who is also a professor at my university, knows that some colleagues listen then in, but they're on matters of law, so you don't have this witness who needs to put on a show, and you don't have the parties who will want to put on a show.
Yeah. I think that's a good point. I think at least in European tradition, civil court proceedings are not made for the audience to entertain. We're not setting up court TV like maybe other countries do. I believe, nevertheless, that there are still technical ways to safeguard personality rights, data protection, and the rights of the judges that might be under pressure in high-profile cases, in civil proceedings. There exist such cases, especially the Dieselgate cases, where there's a high public interest. And in these cases, there should be the possibility to exclude the public, or to limit the public to the courtroom. And so I don't think that it's a contradiction using video streaming of court cases and safeguarding personality rights. It shall be dealt with carefully, and there are technical measures to prevent personality rights, data protection rights, and so on. And if it's not possible to safeguard these rights by design of these instruments, then there shouldn't be a stream. That's how we do it in family cases. When there's somebody to protect, we exclude the public.
Once again, I'm not speaking about privacy rights or data protection. So, that is, I think, second tier. For this, it has to be protected in any type of proceedings. So my question is directed to whether the proceedings or the character for the proceeding is going to change if we, for example, set it up as courtroom TV, and online streaming is just a different means. It's the same, in my view. The effects or the re-effects on the procedure are just the same. So if we are critical towards courtroom TV, why aren't we critical towards online streaming and that's not for privacy rights. It's about whether the procedure as such and the outcome of the procedure changes. But your argument was it's not for the public to entertain them. Right. So why not? It needs to be a public hearing. It's even in the European Convention on Human Rights. It's one of our fundamental principles of civil procedure or procedure as in courts as such, and for very good reasons, but not for the public to entertain. I think, Bart, you very carefully noted all these arguments the Dutch Supreme Court brought forward. What are the conditions? And they tried to kind of argue with them and come down with specific conclusions from that. This all have nothing to do with the publicity in the sense of what is the interest of the public, but what is the function of publicity. And that is, in my view, the question we need to ask more in detail. And maybe the Dutch Supreme Court is right. Maybe there is something missing. So that is the question. And that has nothing to do with privacy rights at all.
Yeah, that's right.
So sorry that I'm so insisting, but I think that is the procedural issue.
No, I,
sorry, there's a hand there.
I agree with you on that issue that it's a different character. I just give the word to Tess Benz, and then maybe we go on with the topic. Tess Benz, yeah.
Yes, thank you very much. Yeah, I completely agree with Professor Lipp, I must say, with respect to we should perhaps more ask the question of what the function actually is of making hearings available public. I mean, we can also try to ask who would actually watch. If you would live stream all court hearings, there would be an abundance of court TV. I think you wouldn't be able to choose. I have like 100 channels on my TV, and I already can't choose what to watch. So yeah, let's not overstate the concerns there. By the way, I currently work in Vienna. I work as a research assistant to Professor Burkhard Hess, and I moved. Well, that means that I now have some familiarity with RIS. And in that context, I wanted to raise, well, or at least address 2 points that Professor Neumeier raised. The first is the concern of against total publication, or at least more publication, even in general. So first, the concerns of anonymization, and I would very much like to hear Professor Krante's opinion on this afterwards. So in the Netherlands, quite a lot is anonymized, and you can, up to a certain extent, question to what extent it should actually be anonymized. For example, if you do private international law, it's quite important that you know the country that you're dealing with, because that may, of course, result in different applicable laws or the jurisdiction of a different court. I've seen Dutch court judgments on rechtspraak.nl that were so anonymized in such a way that it was just woonplaats, domicile, full stop, or well, between brackets, but still, you can't deduct what country it is from. So, yeah, I think regarding the process of anonymization, who does it, there certainly can be some concerns, and there are certainly mistakes. But I'm also wondering whether this process will perhaps become easier in the future, especially with the help of AI. Also, with respect to the comment that, or the argument that judges might fear that the judgment is permanently and publicly available. What's the difference between what we do now with case law journals? We add a fancy comment to it, but it's also permanently and publicly available. You can go into a university library and find it. So I think the concerns are a bit overstated. And regarding the justification, perhaps it's exactly what Professor Krantz mentioned. It is the principle of public access that requires you to give access to these hearings, and perhaps even going further, tying into Professor Nieland's accessibility concerns. I mean, if we make it available, it should also be accessible. It strikes me that especially the Dutch databases are much easier accessible than the Austrian ones. So if I lived in Vienna for 1 month, and I've already heard the quote, well, Gustav Mahler said once that everything in Vienna happens 10, 20, or 50 years later. People seem to have different opinions on it. But could Austria perhaps in this respect learn something from the Netherlands? Sorry, it was a lot of comments and also a couple of questions, but I hope to at least make a small contribution to the discussion.
Thank you very much. I think the first question went to Professor Neumeier. And yeah, maybe you respond.
Yes, concerning RIS, it's a question whether Supreme Court decisions are publicly accessible. Of course, they have to be accessible. In my view, it's differently to see if all court decisions, first instance and second instance decisions, are also public. Have to be public for everyone, because I think there's a difference between matters of fact and matters of legal questions. Of course, all court decisions concerning legal questions dealt by the Supreme Court have to be public. That's also a question of Article 6 of the Convention, but I think we have to discuss more different, and we have to differentiate if questions of fact, questions of consideration of evidence are also published. This would, in my side, and here I agree with Professor Lipp, change the structure of the proceedings on the one hand, And secondly, we have also to talk more about the rights of the involved persons. So the second question was anonymization. Yes, there are projects in Austria doing this with AI. It is the same question. I think it's we wouldn't like court TV in Austria too. So Austria is, I would say, there is unanimity among the judiciary that there should not be public streams of live streams of court hearings. So if you want to attend a court hearing, you can physically go to the court, and this is comparable to the question whether all the decisions of lower instance courts with dealing with facts should be publicly accessible.
Yeah, thank you, Professor Norma, and I think Bart was mentioned as well, considering.
Yes, I was.
Considering publicity, I think.
Yes, it was. So thank you. Yes, that's it. Rechtspraak.nl. I just looked it up. Thank you very much, Tess, for mentioning Rechtspraak.nl. And it's true that it's the Dutch system on access of judgment. It's really accessible. I can show you on the spot. Don't worry, I will not do so. But it's really accessible. It's really easy to find cases. You can find the decision of the Dutch Supreme Court, the conclusion of the Attorney General, the decision of the lower courts, which is based on. That's really accessible, and they're not all there, but the vast majority is published there, and it functions in general quite well. And what Tess also mentioned was the anonymization that takes place. And you are entirely right, Tess, in mentioning that the anonymization, sometimes it goes too far. You mentioned the example of private international. You're entirely right. But also for pure domestic cases, if you want to anonymize, you have to take it seriously. You can leave out the names of the parties. But if you see the address of the house, which is part of the debate, well, you can find the house. If you can find the car, which is part of the debate in the commercial case, or you can find the name of the company as part of the M&A deal, well, you can find almost every detail. So there must be a balance between anonymization and accessibility and access on public nature of the judgment. So I think it's time to redefine the concept of how far do we go with anonymization. Perhaps in some aspects we take the anonymization too seriously, because it might also entail to the fact that it's no longer able to control the hearings, to control the judgment effectively. But I see you raise your hand, Tess. Perhaps you want to react.
Yeah. I just want to give you one very interesting example that I recently found in the case law of the Court of Justice of the European Union that also concerned, well, a fuck up with anonymization. While I was doing research on a case, there was a document on Curia that shouldn't actually be there. It was there instead of one of the application documents. It was instead something different, somewhat of that the name of a party had to be changed because there was an E omitted or something. So a colleague and I, well, we looked at the document and then it struck us that we could actually scan, or at least just put the cursor of a mouse over it and copy what was under it. So there was a black line on it, but for some reason we could still copy the name from it. And because there was a difference between the versions of the anonymized versions, I found out that it was a Maserati. In fact, we were able to trace back to the house of the person involved. Now, I must tell you, I'm not going to tell exactly what case it was because I know it's being recorded, but I just wanted to mention it to show how easy it is, and also that you need to take care of the design of the digital environment, especially with it's not just about blacklining everything. It's also making sure that it cannot be unblacklined through the use of software. So yeah. And also, well, one thing that I forgot to mention, well, it always strikes me that, well, everything is placed in the context of the ECHR, and that's more related to Professor Norma's comment, but just thinking again on accessibility, and also as accessibility in digital proceedings. well, there's also conventions like the UN Convention on the Rights of Persons with Disabilities. To what extent are we actually taking those into account in the design of civil proceedings and in this digitalization process? And in this context, it's certainly worthwhile to mention the recently published, well, I think it was actually last Monday, the ICC guidelines or ICC guide on disability inclusion in international arbitration. I think also for civil proceduralists, it also provides some inspiration and some of the principles that we can actually transfer to civil proceedings.
Thank you very much, Tess. Anna, you've been mentioned as well. Do you want to respond as well on the topic, or?
No, I
okay,
can say I agree.
Good. Okay. As we can see, that depending on the design, how anonymization is performed either by digital means or by hand. Last week I just received a decision of OLG München, and I asked the party to send it to me anonymously because I wanted to just check if there's something in it that I can put an expert opinion on. And there was a handmade line there with a pen that was not very good, and anonymizing a document that is scanned afterwards with a light source, so I could read everything. So it really depends on how the anonymization is performed, and as well it depends on how the video streaming of court proceedings is performed, whether the character of the hearing is really changed. Publicity has its functions, and I think the functions are not violated if publicity is provided by a live stream. It depends on how you set up the system of accessing the live stream and which information is provided on the live stream, if it has any influence on the character of the hearing itself. Because if there are only experts, lawyers, having a meeting and the public hearing is there, and somebody who's public can access the live stream but does not see the details, there might not be any influence on the character of the hearing. But if it's a very important case and stakes are high, then there might be an influence if the hearing is transmitted via the internet, and then the character of the hearing and the publicity might be changed. As well, publicity and publishing court decisions, I think, is also a big issue in Germany, and especially when there is a call for publication of all judicial documents, all decisions of the courts. There are advocates for this, and there are interests, especially in the insurance branch, that court decisions are published, because then they can scan the documents and scan in which regions several judges decide in which way, and then they can adapt their products accordingly. And so I think publication of judgments, whether anonymous or not, is a big issue, especially with the use for outside purposes outside the court proceeding. I think that's also an issue, and I think one has to think about that, whether we use the big data of court decisions for the use of training AI as well, because if we publish every judgment and put it on the website and then make it accessible easily, and AI products are trained with all this data, then even wrong decisions form the decision-making process by the AI, and that's also a problem we have to take in mind, I think. Okay. Well done. Are there other questions? Yeah, Bart.
May I ask one question to Thomas Garber? Because if I remember, you spoke about online hearings and technical issues. and the technical issues may occur also in Austria or even in Austria. Are there any, it's just a factual question, are there any practical guidelines for judges or courts how to deal with those, if an internet connection is interrupted, or there's a technical problem which occurs on one side and the other party doesn't have those technical problems? Are there guidelines or experiences in Austria on that topic?
No guidelines in Austria. We do not know what to do, and we have special remedies, but not for all. But not for all civil procedure. For example, insolvency or law, there's no reinstatement, and it's very difficult to handle it.
Thank you. That's a relief.
So there are guidelines missing.
Exactly. Yeah. We're not the only one who's missing the guide.
Yeah.
Thank you, Thomas.
So maybe Bart, I've got an additional question for you. The Kai, as you said, the Kai project has failed completely, but so one decided to take it step by step.
Yes.
Is there a specific plan how to approach digitalization there? Is there a working group or a set-in?
Yes, there's a working group. I don't know if it's called formally working group. It's part of the Ministry of Justice. There's not a plan from A to Z, but the plans are to do it step by step. And the first focus is now not to make a system which is entirely digitizing the entire proceedings, but to increase digital accessibility. That's the first step. And now we see some pilots going on in Rotterdam. I think since last September or perhaps even October, there's a pilot going on digital summary proceedings. You see district courts setting up pilots, but mainly based on, that's the first step, on digital accessibility. There's also some pilots going on digital seizure of evidence or seizure of certain assets, but it's only step by step. I'm not sure whether there will be more. There are more ideas behind the screens, because if they say, well, we want to go from A to Z, perhaps it will turn out that the same problems with occurred in K will pop up later on. So now they're doing step by step, and who knows what will follow afterwards. But digitization, the communication with the courts, that seems to be a good idea, and that's the process going on.
Yeah. Okay. Thank you very much.
One question which came up when you, Philip, summed up our discussion on publicity. I think also fundamental guarantee does cover that a judgment decision is to be handed down in public. That's for sure. But that is not the same than making every decision public after that. So we can discuss on publication or making available decisions for the public, but this has nothing to do with procedural guarantees. That is about how we regard that as being a service to the public, or whether it's important for developing the law, and what maybe do we want to spread wrong decisions or absolutely horrific decisions in the same way than very profound and well thought of superior court decisions? These have nothing to do with procedural guarantees. And that's one distinction I would like to argue for, that we should be very careful about what we are discussing about. So, and that is related to the topic we touched upon after that, speaking about accessibility. There's quite a difference whether it's about accessibility for parties to a procedure, whether we would kind of making that easier by using digital tools, whether it's about accessibility for the public, that is about a publicity issue, or whether it's the accessibility for people with some disabilities, etc. So we can all call these accessibility, but there are very different issues. And I want a specific point. When you, in your first speech, gave some examples which were quite highlighting some problems, which came along very practical and more technical, whether we now have the chance to update documents in if we have an electronic system of hearing. Is it just a matter of practice of electronic technology, which we haven't had before? Or is it about the procedural issue that we need to keep track on how proceedings have been conducted and whether something which has been later made needs to be struck out because it was beyond the time limit, because it was for delaying the proceedings, and if we just update documents, it's very difficult to keep track of all those changes in the due course. If you have kind of a very traditional one, you can also transfer that to the digital world. That is not a problem. So the role of the timeline of the proceedings is not just a merely documentary or practical thing, which is comes or stems from the paper world. It has a procedural sense in it. If we just digitalize that and say, oh no, we can update documents now, that's far more convenient, etc. And then we have kind of a SharePoint, everybody can write in the document at the same time, and somehow the system will sort it out or not. And there might be some mistakes in that. So does that really serve the necessity of having a proper documentation that need not be in paper, but a proper documentation in any form, regardless which technology we use? And maybe, and this is also one of the reasons why the project was so becoming more and more difficult and more expensive, because then in the ongoing process, people realize that they need to take care of all those issues, which they haven't thought before, because it's also, they regarded this as being so simple at the beginning. It's not.
Yeah, thank you very much, Volker, for the comments that are, I think, true. I think Anna will reply on that.
I didn't suggest that we wouldn't keep track. I think it's very important that you keep track and you put limits to it. It's just that I said, my suggestion is that we need to imagine and look at the opportunities that's there. But of course, we sort of need to keep track of things, and you have to be able to go back to previous versions then of how we resolve that is another thing.
I have one final remark on the question of
course, you have the final
fundamental principles and the issue of publication of judgments. I agree with you that it's generally a topic just as a service, publish all judgments or major judgments, but it becomes a procedural issue when the data that is published is used in the process of generating a judgment. For example, if we start to use artificial intelligence to structure proceedings, to make draft decisions, then we have a procedural issue. I just want to make this point, but I totally agree with you that the simple publication is not the issue of procedural guarantees. I have Felix Wilke as in the online room with a comment.
Yes, hello. I hope you can hear me. Cannot quite well brag as Professor Neumeier did that I'm in the hospital, but I'm in my kitchen right now because I have to watch my two daughters at the same time. So I apologize if the sound is not okay. Good to see everybody. I'm very happy to be a part of this via Zoom. Thank you for the opportunity. I have a very basic question, but of course it's very broad at the same time. With all these differences at the national levels, at least for the European member states, is there any role for the European Union in this? Because we do have European Union influences, of course. You talked a lot about the fundamental rights and Article 6 of the Convention. So we have at least something on the European level. We can, of course, talk about the Charter of Fundamental Rights, Article 47, when we talk about Article 6 of the Convention. Maybe there is even something to be said for the the so-called procedural autonomy and its limits. It picks up maybe effectiveness if we're talking about consumer rights, and maybe effective enforcement of consumer rights in civil proceedings means certain digitized tools that must be available at some point. So this is just a very broad question, just some very initial thoughts on this. But as somebody who's very interested in European civil procedure, I felt obliged to touch upon this European dimension. And if you have any input, I would very much appreciate it. Thank you very much.
Thank you very much for the question. Does anybody? Yeah, Anna.
There is an ongoing ELI project on digitization of civil proceedings. So we'll see what comes out of that. But 1.5 years ago, I was talking at a conference in Poland. And then some of the colleagues there talked about this problem with if you record what's been said during the proceedings, that somebody then, probably administration, might break into it and then use it against you. So, and that's sort of the fundamental difference that I realized how naive I was to trusting that if we make these recordings, that for instance in Sweden, that they're safe there. So I think that as much as this could be a nice idea on a European level, I think we come from very different starting points. So I think it would be overly broad and lead us nowhere. So I think it's better than to do it as a soft law initiative.
Yeah, thank you very much. Any other remarks on that?
Yes. Thank you, Felix. That's a very interesting question. And I think there is at least some part of the European influence already. Of course, Article 6, as you mentioned already, that gives just a basic line. There's a basic line. At the same time, we do have the concept of procedural autonomy, which means that it's up to the member states how to deal with these rules themselves so far. And still, at the other same time, we see that as part of the anonymization is there, we see how Strasbourg is dealing with the anonymization. We see how Luxembourg is dealing with it. They do not deal with it, as far as I know, exactly in the same way. So you see there's a difference on those sides. But I don't think it will be very likely that we'll have a European rule on how to deal with all these aspects on the national levels, because that will be left over to the national member state, just as Anna said. I think it will be a bit too far-reaching to expect rules on that so far, but any ideas, very welcome.
Yeah, and anyway, we have broad approaches, I think, on the EU level to connect communication between the member states' courts, e-codex, and these are influencing our systems as well. So we have a big integration there, and I think a long way to go still to reach the topic. I have just one comment on the editing documents issue. So in Germany, we've got a project currently, a Bavarian and Lower Saxon project on so-called Basis document, which is a central document that should pre-structure the proceeding. And I think if one sets it up in the right way, then one might be able to track all the additions made and just to highlight how the document evolved. At the moment, it's not AI-based, but if it's AI-based, we'll have an additional difficulty to keep track of how the document evolves. And I think it's an important issue to ensure the involvement of the document on the time scale, just to allow the parties to monitor and higher instances to monitor the case proceeding. And otherwise, you lose track and you don't know how the judgment came to life, and that maybe makes fields more difficult. Yeah.
Yeah, I think that's a very good example. Thank you for that. For my argument, so I'm pretty much in line with Anna, saying these new developments they force us to rethink these what is procedurally necessary and what are our procedural issues we have to deal with. And we need maybe to rethink one traditional ways of dealing with that. And this example by you, Philip, that is what another example which illustrates it very well. So if there is a way of doing that, and so the authenticity of the proceedings is guaranteed in that way, fine. But given what Anna told us about AI, quotation marks, yeah, that is the point where it's going to be very difficult, for you don't know how AI actually recomposites those documents. Because that is the very nature of that tool, that you cannot keep track of that. So, of course, I'm pretty sure that many of the experts will say, wow, now we have this powerful instrument called AI, and let's use it for that purpose. And on the first side, it's very convincing, maybe even on the second side, it's a very effective and powerful tool, in fact. But if we realize that that it's an absolute precondition that we have the authenticity of the course of proceedings documented, guaranteed in which way soever, then it's no good idea, I dare say, to use that tool for that purpose, because then the authenticity is just trust AI. And we don't know what it's going into the black box, and we don't know what's coming out of that. And we don't know the algorithm because it's a self-learning system. So it's more a statistic authenticity we get. And that is, I think, not up to what we need for civil procedure or for procedure as in general. So that's why, yeah, the question is, what do we need? And is that a tool that actually serves us to get to that goal in a better way than we just did traditionally? But we need to know what the goal is and what the task that to be fulfilled is, in order to be able to judge whether this is a good tool or not.
Well, you said it. You know what is coming out. It's salami.
Yeah, thank you, Volker, for putting emphasis on this topic, and I think that's also a position I'm arguing all the time, that we shouldn't use digitalization instruments just because they are new and fancy and digital. Digitalization in civil procedure must serve the process and must serve the fundamental guarantees of the process. And now that's the starting point. The starting point is the process and the functions of civil procedure. And when we depart from that point and start using digital tools to facilitate the goals of the process, then we are on the right track. Okay, are there any questions or comments? Just looking at the YouTube chat, there are no remarks. Okay, then let's say thank you to the presentators on the screen, online, and here in the room. Thank you very much for your excellent presentations and the insights to the developments in the countries and in general how to approach civil procedure. I really enjoyed coming together here in Göttingen and to welcome you as international guests here at the faculty. It's a pity that Thomas and Mr. Neumeier, you couldn't come to Göttingen, and this basically is another example for Volker's argument that the structure of the whole thing changes when we go online. So I would love to welcome you here next time. So we'll follow up with a colloquium on comparative issues in the future. I have to mention now what Philipp Hermann has kindly put up on the screen, which is our new volume on these colloquia. You can buy it for sure online in the online shop of the university publisher, but you also can access it online, open access, without any cost. So we provide that for you. There's QR code you can scan, and then you can directly enter. Let's also forecast to the next colloquium, which takes place on the 2nd of February, when, if I right recall. We are coming together merely online now, so we don't change the structure of the colloquium entirely. We keep with the flow we normally have. We've got interesting speakers here. We're talking about the future of civil procedure in Germany, with regard especially to strong competitors, in inverted marks, because I don't think the civil process should compete with these, compete for claimants. I think we're talking about the future of civil procedure with regard to especially legal tech institutions that address small claims, like Flightright or Connie. We used to regain claims legally, and we will talk about alternative dispute resolution, especially arbitration proceedings. We've got excellent presenters. We've got Stefanie Otte, who's the president of the High Regional Court in Celle, and one of the key experts in the field. From the practitioner side, we've got Jean-Claude Paulus Saw, a good friend of mine, who's working at the German Institution of Arbitration, the Deutsche DIS, Deutsche Institution für Schiedsgerichtsbarkeit, and we've got Malte Stübinger from the D-Minor Recovery Services Group. So we're really looking forward to it. If you haven't joined the event already online, so please do it. If you're interested in it, you can do that on www.reusz.eu Veranstaltung. I don't spell it out now, it takes too long. Thank you very much. And all the best for tonight. Have a nice evening. Thank you very much for joining this event. Best wishes to Graz and Vienna, I think. I don't know where you are exactly at the moment. Greetings to the hospital at least, and see you next time in Göttingen virtually. Bye-bye.